Well, we just had another great experience in the corrupt judicial swamp. Today, I had a change of venue motion to be heard in the Ontario Superior Court in front of Justice Phillips. Now, a change of venue motion, for those who aren't aware, is to ensure that an individual can have a fair trial, that they can select a pool of jurors who are impartial, unbiased, and have not been overly exposed to either negative or positive influences in the media. As we know, my criminal charges in Ottawa, as a result of our freedom protests in February of 2022, were highly politicized, highly publicized, and everyone who partook in those protests were vilified by the federal government, by the provincial government, by the municipal government in Ottawa, and the media in Ottawa. It captured the news in its entirety for 3 weeks. So many people have viewed that Ottawa is not only a place where you cannot get a fair and impartial jury, but the jury would be hostile to any of the defendants. So my application today was dismissed without being heard. It was dismissed summarily. So the arguments were not argued. The information was not tested in court. While I was watching, Justice Phillips had the audacity to suggest and state, didn't suggest, he stated, because the facts are different in my case and other cases, but even if that may be true, facts are subjective, is what he stated. Now, for anyone and everyone, we understand that the courts rule on both matters of fact and law. And facts are not subjective. Opinions, perspectives, many things are subjective. But that is what defines a fact. It is objective. But here we have a judge in the Ontario Superior Court stating boldly, brashly, that facts are in essence not facts. They're subjective. I was born and raised in Ottawa, have a long history and attachment to Ottawa. In addition, I'm an elected representative who was widely quoted, widely publicized for the last 20 years due to my advocacy and my representation, first with the Lanark landowners, and then as an elected representative in the Ontario legislature. There was a week where my name and picture was not in the Ottawa news. There are few potential jurors in Ottawa who are not familiar with my name and will not already have had a predisposition to whether they like me or not like me. They're impartiality will be in question because of my well-known advocacy for over 20 years. But according to Justice Phillips, that's irrelevant and subjective. The bulk of the case against me by the Ottawa Crown is significantly, if not wholly, dependent on my postings on social media, Twitter, Facebook, etc., as well as the demonization of me on social media during the protests. They even had a hashtag arrest Randy Hillier trending in Ottawa. This judge today, in a very flippant, casual, with a wave of the hands, declared that Twitter is not real and has no relevance to my application. And here we go. The Crown's entire case is based on my social media accounts. In my bail hearings, the bail judge said Twitter has criminal consequences. So we have one judge says it's real and it has consequences, and another judge saying it's not real. This is going to be a long process to fight, defend, and gain back our freedoms. I hope you can help us out, help me out. The Ottawa Crown is doing everything that it can. They're trying to bankrupt me or ensure that I can never speak again. Freedom needs a voice. It needs all our voices. If you can help out, donate to my legal defense, spend some time up here at Scuttlebutt Lodge, go on the nomorlockdowns.ca, and let's make sure freedom always has a voice in Canada.